Very much, Mr. President, for the opportunity to join in this debate. Mr. President, I want to just immediately start by saying certainly I have to probably have a conversation with Senator Lakshmi Dayal after this. Clearly, the senator has a link that the government doesn't have, because sitting in the office of the Attorney General and Ministry of Legal Affairs, it baffles me that the opposition had a copy of LAT's comments and the criminal bar comments to date, which was issued today, and up until now, the office in which I sit in, we have not received those comments. So maybe the Senator and I can have a conversation. Maybe the opposition clearly has a link that is unbeknown to us. But I will leave that there, Mr. President, because, of course, the bill which we're about to debate today, especially coming from my experience and my practice and the chambers in which I came from, of course, I understand the importance of, some of the concerns, even raised by Senator Lakshmi Dayal, and I'm sure it may probably be some of the concerns that would probably be operating in the mind of especially the independent senators, who, of course, many of them are not legally trained. And as a consequence of recognizing that, Mr. President, I believe that this debate requires a very sober, a very, very sober approach, an intellectual discussion as best as I can to, take the honourable senators through what the amendment that the government is bringing here today, what it intends to do. Now, Senator Lakshmi Dayal, Mr. President, in her presentation would have, to my mind, I would have itemized three concerns that the senator would have raised. Of course, one of those concerns being the statement, my interpretation of the senator's concern is that the accused, and also it's a concern that was raised by Senator Welsh, that the accused is being denied a jury trial by the amendment that is proposed, I believe, in Clause 4 of the bill that appears before us. So that's one of the concerns. Another concern, of course, raised by Senator Welsh and also Senator Lakshmi Dayal was that concern of the downsizing of the jury, suggesting to my mind that justice in some ways being compromised in the interest of cost, or the reason why this downsizing is happening is as a cost-effective measure that this government is engaging in. And the third point that, of course, Senator Welsh would have gotten into in his contribution was relative to that whole structure of lay assessors. And it's predicated on these three major points, Mr. President. And as I said, I'm sure it may be also concerns that other members of the Senate may have. It's predicated on those 3 points. I'm going to more or less steer my presentation and my contribution, again recognizing the need for us to have a sober debate, an intellectual discourse and discussion on what the amendments here are proposing to do, recognizing based on the background that I come from, the criminal background in which I come from, recognizing how critical it is for us to be able to safeguard and to protect even the rights of the accused. And of course, balancing that, the protection of the rights of the accused with protecting our society from the infiltration of crime and criminal activity that occurs. Now, Mr. President, so that is the context in which I intend to make my presentation and, make my contribution. Now, Mr. President, I want to jump into immediately Clause 4 of the bill, and it reads, a person against whom an indictment has been filed shall, subject to the provisions of this act, be tried by a judge alone, unless he elects to be tried before a judge and jury, and the court so directs in the interest of justice. And I could understand that the fear or the concern can very well be that of, and Senator Welsh would have made mention to it, that part of the clause that says, so directs, and the court so directs in the interest of justice. Because what it appears is as if, we start from the point where it's trial by judge alone. the accused elects whether or not he wants to be heard before a jury. And then, of course, in the interest of justice, the court so directs. And I can see the concern being raised there. And of course, this is drafting. It's a matter of the expression and how it's expressed in the clause and the bill that appears before us. And I am most certain that when it comes to the semantics of the way in which the clause is stated, I am sure that perhaps the Attorney General, after consultation with the drafters, if that seems to be a critical concern of the Senate, that part that indicates the court so directs in the interest of justice, that suggests that a court can then say no. Accused say, I want a trial by jury, and the court says, nah, this is not going to happen. I'm sure because this is an issue of semantics, that is something that we could probably address our mind to when it comes to the expression in this particular clause. But notwithstanding that, Mr. President, I have to place on the record that the policy behind this clause was never intended and is not intended to deny the accused who elects to be heard before a jury from having that done. And I need to place that on the record. And that's why I'm mentioning that if it is a matter of semantics and it's a matter of expression, it's a matter of how this is drafted, I am most certain we on this side will hear, of course, some of the concerns by the honourable senators. And that is something, even at the committee stage, the Attorney General may very well be minded after consultation with his drafters to readdress his mind too. Now, what I must also place on the record, Mr. President, is the interpretation of the clause again is not to give the court the discretion to deny trial by jury if elected, but rather, Mr. President, is for the court to direct the jury trial in the interests of justice. And that was the intention and the interpretation and what operated in our minds and the policy that drove this particular clause. But again, if the semantics and the structure of the clause is an issue, again, it's an issue of drafting, and it is something that can be revisited. But it must be understood by all those in the Senate and especially members of the public that the intention of this clause was that the court to direct a jury trial in the interests of justice, not for the court to say yea or nay when the accused exercises his rights and say, I want to be heard by a jury, as opposed to being heard by a judge alone. Now, the court has to direct once the accused elects, and the judge is, of course, and the judge then
Minister,
gives the necessary direction.
Senator would ask to give way, if
right.
you would allow.
Can I?
Of course.
Right. I just want to ask a question. Right now, the law as it stands right now is that the default position is judge and jury, with the choice of choosing judge alone. I need to understand why there is the need for the change. I'm not yet getting that.
So if I may understand the Senator's question, you're asking that why we are starting now with judge alone, and then the accused will then make that decision as to whether or not he elects a jury. And my simple answer to that, you see, to my mind, especially coming from a criminal background, I am seeing that the accused still has the option, even though, yes, we are starting with a judge alone trial. The very fact that the accused is still given the option to decide whether he wants to be heard by a jury, that has not been taken away from the accused. You understand? So even though it has been switched around, where we start from the position, and I will get into, and why I will get into when I look at the downsizing part of the jury in particular, I will get into some of the other considerations. And of course, it's not, I don't want, when I get into that point, Honourable Senator, I will be touching on some of the realities of the selection of a jury, all right? And of course, I will have to traverse the point of cost and the process involved. It's not just simply, you know, I heard Senator Welch mention whether we are downsizing because, of course, it's less food. honestly, when I get into that part of my submission, Senator, you'd realize it's beyond just simply food for selecting a jury. So to answer your question, in considering, of course, a resourcing issue as well, to my mind, it is best to start from the judge alone structure. And I'm not seeing the rights of the accused being taken away, because even though we start at this level, the accused still has the right and the option to say, well, I want to be heard before a jury, as opposed to, and I think that is what our focus has to be. Our focus has to be, is the rights of the accused to have a fair trial. Now remember, constitutionally, an accused does not have a right to be heard before a jury. The constitutional right of the accused is to have a fair trial. And the mindset that we ought to have in looking at this clause is whether or not this clause seeks to take away that right from the accused. And my suggestion is, even if we are starting from the point of where this is a trial, we are starting from the point where it's a trial by judge, and we give the accused the option to elect whether he wants to be heard by a jury or not, that is clear enough to show that that right, that constitutional right that this accused is entitled to, that right has not been abrogated. We are not taking away from that right. We're giving the accused, we're giving the accused the option to decide. And you see, this must also be taken, and to answer your question too, why are we starting? Why have we flipped the position? That is where, when I get into my submissions and going through in detail the process in electing a jury, the financial cost attached to electing a jury, hopefully you'll be able to understand why it's our policy position at this point. Let's start from the point of the jury, from the judge alone. Give that accused, the right to decide whether he wants to be heard before a jury or not. And then, of course, because in that instance, we're not taking away his constitutional rights to a fair trial. Now, clause, so that was just to place on the record, Mr. President, relative to what our mindset and what our intention was relative to that particular clause. And I'm sure, of course, the semantics, I want to reiterate the way in which the clause is structured. Perhaps that may be the cause of the concern, whereby it appears as if the judge can then decide yea or nay to whether or not we will proceed with a jury trial. And because it's a matter of drafting, as I said, I'm most certain the Honourable Attorney General will be minded to hear some of the concerns and readdress his mind to that, of course, after, consultation with his drafters. Now, I want to immediately jump into the discussion that we have had this morning relative to the reduction in the size of the jury. Historically, if I may get into a little bit of history, brief history about the composition of a jury. The number 12 and 12 juries, the jurors that sit, there is no empirical data. There is absolutely no evidence that suggests in any jurisdiction and any reading that I have done that 12 is better than 6 or 12 is better than 9. As a matter of fact, when we look at the history of the 12, Mr. President, I may go back, and it's surprising Senator Welsh brought the issue, because it was actually the Welsh King Morgan of Glamorgan who established jury trials in 1725 AD. And in 1725 AD, to be very honest, the reason why 12 was selected was because at that time it was because of Jesus Christ and his 12 apostles. And when that 12 was selected as a jury, that is where the emergence of that 12 jury came from. And the reason why I bring that up, it's of course because it was not that mathematical figure 12. It was not as if that there was data to drive to believe that for some reason an accused had a better opportunity or better chance or a fair trial by being heard by 12 jurors. Now, added to that, Mr. President, in Trinidad and Tobago, there is the Privy Council case of Trevor Stone versus the Queen. And it's ruled that a Supreme Court judge sitting without a jury is simply a matter of practice or procedure, and there is no infringement of the entrenched constitutional rights. So I just want to put on the record that particular case, which also bolsters the position that I earlier stated, where I spoke about, the issue here should be whether or not the amendments we are bringing here today, whether or not it's going to deny the accused of a fair trial. And I'm saying that in this Privy Council case, what the learning, some of the dicta that comes out of the case is, of course, that is not, a judge sitting without a jury is simply a matter of practice and procedure. And the Privy Council is saying that there is no infringement on the entrenched constitutional rights of the accused. Now, I also got into, Mr. President, the constitutional rights of the accused, which is really that right of a fair trial. Coming now, jumping up into the dance of the reduction of the size of the jury, Mr. President, I respectfully submit to the Senate, which I have already done, is that it will not infringe the right of an accused to a fair trial. Because, of course, we must balance the right of the accused persons, of course, and the practical benefits, Mr. President, the practical benefits of a smaller jury. And this is where now I will jump into some of my personal experiences, because I know Senator Lakshmi Dayal would have spoken at length about some of her personal experiences, and I want to join the Senator in also sharing with some of my personal experiences. Now, we are looking at, even if we reduce the size of a jury from 12 to 6, I want this Honourable Senate to be reminded that this jury is still going to be selected from a cross-section of society. So we are looking at persons who sit there are going to be persons who have varied social backgrounds. These are persons from various economic structures. These are persons who are bringing their own experiences to, of course, their deliberations. So let's understand that. By reducing the size, we are not, even though we are reducing the size, the amendment proposes to reduce the size, we are not reducing the fact, that does not take away from the fact that it's still going to represent a cross-section of different persons who sit, the regular man on the street, the PTS, the priority bus route person, I think Senator Lakshmi Dayal talked about in her presentation. That 6 is still going to be very much representative of our society. Now, added to that, Mr. President, I believe what is also critical in looking at the 6 jurors that we are proposing in the law today, I have personally, and I agree with Senator Lakshmi Dayal, the impaneling of a jury sometimes just takes place in the morning of the selection of your trial. And yes, it's not that it will go days on end in selecting a jury. I agree with that. But I also agree, but I also have to state that I have sat into those sessions in which you have juror after juror giving excuses for why they do not want to serve. And the point is that so sometimes it may seem as if we may have 72 people who is called upon for jury duty. But I have sat in where sometimes you can't even get 5 people who are willing to be able to serve as jurors, and some of them have legitimate concerns, and as a consequence of that, the court they cannot be bound to serve as jurors. And that has been my experience. And I am here representing an accused person whose matter is now finally for trial, who has been probably in remand for X amount of years, well, of course, depending on the matter that is before the court, and I now have to wait and pray to God that I can have a properly constituted jury before my client, who has already faced the wrath of being in prison for an extended period of time, before I could even get 5 men, much less 12 men, to sit and adjudicate over this, to listen and to, for this matter to proceed. So I want to also remind the Honourable Senate that it is not as easy as it appears. And I see Senator Sagramsingh-Sooklal, and I know Senator Sagramsingh-Sooklal comes with a wealth of experience at the criminal bar. And it's nice to see you here, Senator, and let me recognize you. And I'm sure the Senator, if she is fair to this debate, which I'm sure she will be able to draw on her experiences and some of the trials and tribulations that you often face even in impaneling that jury. And from a defense perspective, I am saying, and this is not simply because I'm sitting in government now, I believe that there is merit to the reduction, even and more so in the interest of justice and in the interest of your client's matter being expedited and not having to be further derailed because we are waiting to have a properly impaneled jury. Now, Mr. President, with that being said, I want to get into, again, making reference most respectfully to a submission that was made by Senator Welsh. Of course, when the senator spoke about the reduction and asked the question whether or not, we are just looking at, whether we're going to reduce our food bill if we have less juries. And at this stage, I must place on the record, Mr. President, and at least for the benefit of my colleagues in the Senate, to understand the behind the scenes now of the judiciary being able to create a pool of persons who can then be put forward before the prosecution and before the defense, before a jury is impaneled. And I believe that conversation and that understanding is critical, because then I'm hopeful that once this is placed on the record, members of this Senate will understand why the policy position now, we have had to, as a responsible government, we have to take the real woes and concerns that sometimes will face the judiciary and the cost factor that it entails in creating that pool of juries. I'm not talking about 12, because remember, people, we are looking at 12 juries. That's not where it starts. It don't start with 12. It starts with about 72 or 75 persons who come before you, prosecution and defense, and then you choose 12 from that. So I need to go not just to the 12. It starts the process, and the money and the expenditure that goes into a jury is not from the point of where you have 12 impaneled person. It is beyond that. And that is what I need to remind this Honourable Senate about. Now, Mr. President, the average cost for a jury trial, if I may respectfully place, and I must say, and I want to reiterate, this is not in any way my attempt to say the rights of the accused is not important. This is in no way to say that cost trumps the interests of justice. This is not my intention. But my intention is simply for this Honourable Senate to understand the process that goes into and the cost factor that goes into to even getting that 72 odd men and women to stand before the prosecution and defense before you could even dream to impanel them. The cost that goes into that. So we are talking about feeding the 12 during the course of the trial yet. We haven't reached there yet. We're talking about just to get a group who's impaneled, right? Mr. President, so for example, the first thing that has to happen is jurors. You have to serve jurors, potential jurors, right? At least 72 summonses, if I'm using 72 as the figure, has to be sent out by the judiciary. Mr. President, if I may place on the record, a team of staff is sent out countrywide from the judiciary to find these persons. Mr. President, this requires the marshal's assistance in order to be able to go throughout Trinidad and Tobago in order to get these 72 persons. So mind you, I'm saying again, we are reached where the 12 men sitting in a jury to listen to a trial letter. We're talking about, we're just trying to get together 72 people who could come before prosecution and the defense for us to choose. So we're looking at, the court has to expend money for marshals. The court has to get travel cost. The court has to, sometimes you go back to one person, a potential person on that list. You have to go 3-4 times to find them because man ducking jury when they hear the court looking for them and marshal looking for them. That's the reality. That's a cost factor attached to that. Mr. President, the system to send out the summons to these 72 persons, there's a cost attached to that. Mr. President, the system to create a national jury list requires the assistance of EBC. It requires the assistance of the magistrates court to get that countrywide 72 persons. There is a cost attached to that. Mr. President, the jury call takes 1 full day. a full day sometimes, as Senator Lashmidial alluded to. The cost attached to that full day of hearing excuses after excuses, after excuses, for you to even dream to get 5 man, much less 12 man. There is a cost, a real life cost, Mr. President, attached to that. Mr. President, if I may also go into the arraignment and empaneling of a jury, Mr. President, is another day. That is a cost attached to that because you're talking about you're preparing refreshments for them. You're talking about you have them there waiting. That is a cost. So respectfully, I do not want the Senate to believe that we are trivializing or we're putting cost over or cost in any ways to trump. Of course, it's not that cost is trumping the rights of the accused. But certainly, as a responsible government, one, we have ensured by the amendments, we are not infringing upon the constitutional rights of the accused to have a fair trial. So that is the reality of the amendments that we have brought here. But the reality is that in the interest of the administration of justice, in the interest of resources and resourcing issues, we have to bear in mind the realities of the cost that is attached to being able to have 72 men in the first instance appear before you can even decide who is the 12 you're going to select to appear before to listen to this trial. And it goes further, Mr. President. You have food for juries. Yes, that is what Senator Welch would have alluded to. That is a cost. It is not a trivial cost. We have court buildings have to be bigger to accommodate jury deliberations. That is a cost. If it is, we have 72 persons. I have often seen where sometimes, well, of course, mainly is the criminal courts, which are the larger courts, often, at least at our High Court. Excuse me, Mr. President, here. That is a cost attached. There is a cost attached to that. Mr. President, there's a security cost when you bring the 72 persons there. Because we have to also bear in mind the safety of these potential jurors. And security is a real issue that the judiciary, of course, it's an expenditure that will have to be footed by the judiciary, and resources will have to be to be allocated for that particular cost. Mr. President, there is also a cost of assisting jurors' families, which is something we have to bear in mind in getting that 72 persons ready. And that, Mr. President, of course, the cost attached to that is in instances where you have a single parent or you have single families who now have to come on down to serve as juries. Now, of course, all of these things, and mind you, even Forget the 7. So I spoke about the 72. Some of these costs that I'm referring to, Mr. President, will also apply when we have the 12 jurors sitting there. You understand? So yes, I've spoken about there is a significant cost prior to getting them to the court, but everything that I've made mention to, where you have to cater especially for a juror's family, where there is a single parent, and accommodation, Mr. President, has to be made for children. School transportation. This is so the juror could focus on the case and not be otherwise concerned about, okay, well, I'm a single mother, my child is home, who going to take? That is a cost that the judiciary bears. And I need this Honourable Senate, I need this country respectfully through you, Mr. President, to understand that this is not just a matter of food. This is not just a matter of 6 lunches instead of 12. This is a significant cost that we have had to consider. And even if it is that 6 persons could help and reduce that cost, Mr. President, it is something that we have considered. We understand that the amendments that we are bringing here today, that it is in no way at all intended to affect or abrogate the right of the accused to have a fair trial. But certainly, if we could maintain the interest of justice and at the same time balance that properly with saving the state and saving expenditure, then what is criminal about that? What is wrong about that? To my mind, Mr. President, that is responsible leadership. Mr. President, if I may also say another cost, and I'm going through the cost because I know because this is one of my submissions relative to the reduction in the size of the jury. Mr. President, we must ensure that all jurors are up to date with technology. That is also and we saw that, well, of course, the pandemic would have spun, that things would have just gone out of whack during the pandemic, where we realized how critically the technology, how even more critical it was back then during that time. But that also bears a cost to it, Mr. President. Where there are late night deliberations, Mr. President, we must provide, the judiciary must provide transport for jurors from the court to their homes. That is a real life cost attached to it. And I've gone through in some detail, Mr. President, the list of the issue of cost, and with the expectation or the hope, Mr. President, that this Honourable Senate understands that this is simply not a matter of food. This is not a trivial matter. All of these factors would have had to have been considered. And certainly, we are of the view that if it is the reduction, we believe that the reduction can certainly assist in the reduction of some of that expenditure that I would have gone to length on deliberating in bringing forward to the Senate today. Mr. President, what I also want to say, Mr. President, is that we must remember, if we have a reduction from 12 jurors to 6 jurors, so yes, we are proposing the reduction. Please remember, it is both the prosecution and both the defense who they both stand on equal footing in trying to convince these 6 persons as to whether or not they believe the prosecution's case or the accused's case. The reduction from 12 to 6 does not put one party in a more advantageous position than another party. Because it's the same 6 that both the prosecution, both the defense is going to have to appear before, and both the prosecution, both the defense is going to have to convince as per the merits of their particular case. And I just needed to respectfully remind the Senate about that. And one thing I know Senator Lakshmi Dayal made mention to in her presentation, but it was, she didn't get into it. It's something that I want to remind the public and, of course, members of the Senate of, is Section 23 of the Jury Act. And that speaks to the whole challenge of the empaneling of a jury. And what that Section 23 of the Jury Act speaks to is, and the reason why I'm mentioning it, why I want to get into this, is because, of course, that is to remind honourable senators that even though we have a reduction in size, Section 23 of the Jury Act still stands, and that is a section in the Act that contributes significantly to both the defense and the prosecution having some level of control over the persons who are impaneled to sit as jurors. And of course, operating in both the prosecution and the defense mind will be, let me impanel a jury. Once the jury is being impaneled, let me look at the court, let me make a decision as to who I'm going to object against or not in the interest of my client. And I'll give you a perfect example. I'll be very honest. In practice, if you are doing a rape matter, for example, I noticed, if it's my colleague and I, usually we did those matters together. And one of us, our strategy was, once you're doing the impaneling of the jury, my responsibility was to kind of assess these jurors. And if I find somebody looking too churchy or too prayy or in a rape matter, I can evoke my Section 23 right under the Jury Act, which is I'm allowed 3 challenges. And I can reject 3 persons based on just the mere fact of how they look. And I have to not, Section 23 says, it requires no prosecution or defense to give a reason for the rejection of that particular juror from sitting in the panel. And that section 23 right is also further. So in other words, both the prosecution and the defense, once you're impaneling a jury, you have that option to deny to say to the court, I am not in agreement with these three jurors. Both the prosecution and the defense has that option. Section 23A, of course, of the Jury Act then goes on now to speak about with cause. And those are the instances where now both the prosecution and the accused can then advocate and make a submission to the court as to why they do not want, of course, certain jurors to be impaneled. Of course, they have the Section 23, big A in the Act, spells out the parameters in which you can make said submissions. One example, for one scenario is, for example, if the accused says to you, well, I know that man. He lived in my village, or he and I had some run-in some time ago, whatever. Then, based on Section 23A, you can raise a with cause objection to this jury being impaneled. Now, why am I going through this Section 23 of the Jury Act? So that persons understand that even though we are reducing the jury from 12 to 6, the accused and the defense and the prosecution still have the provisions of Section 23A, Section 23 and Section 23 big A, the provisions provided there to determine to a great extent the persons that forms part of that jury. And I believe that we cannot look at the reduction in the size of the jury without reminding ourselves of Section 23 of the Jury Act. And the fact that Section 20...
Senator, you have 5 more minutes.
Yes, and the fact that Section 23 of the Act, of course, gave allows for that. Mr. President, well, time surely flies. I wish I had 2 days to debate this bill, but the time surely flies. Mr. President, if I may now, well, with the limited time I have, get into the issue of lay assessors. Now, I want to also place on the record, and especially for my colleagues in the Senate, please, who are not legally trained, let us please understand when we speak about judge alone trial is not a new phenomenon to our jurisdiction. Certainly, it is new relative. It was new to our jurisdiction in criminal matters. But if we look at the civil courts, for example, in the civil courts, it's a judge alone trial. And a judge is required to both assess the facts and the law and come to a determination. If we look at family matters, it's judge alone trial. Those matters go before a family judge who in his discretion makes a determination on the evidence and the facts of the case. In magisterial matters, for example, when we have magisterial matters, granted it's not a judge, but it's a judicial officer nonetheless, we have magistrates determining matters on their own. So I just wanted to respectfully remind the public, and of course, members of this Honourable Senate, which I'm sure they are aware of, that this judge alone is in no way an attempt for us to stifle something new and it's out of this world and it is exception. No, it's not. Even in our local jurisdiction, yes, albeit it's in the civil court, albeit it's in the family court, in the magisterial districts that exist, but we have the existence of where the judge alone sits on these matters. Now, Mr. President, again, well, time certainly is against me. If I may respectfully get into, if I can, section clause 6H2, of the bill that appears before us. It's just one of the parts that speaks primarily to the interests of justice. And it says, where the judge is of the opinion that it would be in the interest of justice that the assessor or assessors assisting him do not take part in any decision upon the question of evidence, whether evidence, of any confession or other statement made by an accused is admissible as evidence against him, the judge alone shall decide upon such question, and he may for this purpose sit alone. Mr. President, this particular clause, Mr. President, I believe that It is critical because, of course, this is where, of course, you give a judge, where a judge who uses the assistance of lay assessors could then decide, of course, in the interest of justice, what weight, if any, I'm attaching to the assessment of the evidence made by lay assessors. And, of course, certainly, again, because of time, I'm not going to have the opportunity to get into this. And as a consequence of that, Mr. President, I just want to simply reiterate certain points, very, very briefly, as per why I support the lay assessor structure. You know, in the civil courts, for example, Mr. President, and granted the structures are very different, so please, I hope I'm not misquoted where I'm making where I'm saying it's similar. The structures are very different, but I need to mention what happens in the civil court with expert witnesses. In the civil court, oftentimes expert witnesses are called upon to assist the court when the evidence is of such a technical and an intricate nature that even the most learned judge cannot comprehend and understand the severeness and the technicality of the evidence. And in the civil arena, we have seen the benefit that these expert witnesses prove to the understanding and assessment of evidence. Again, because time is against me, very simply put, Mr. President, the intention of these lay assessors and the structure of these lay assessors is to lend that judicial officer that support that he may require, of course, in the understanding of complex matters. And of course, yes, there are a list of matters in which the bill, of course, identifies in which lay assessors can be used. And so, for example, let's say you're dealing with an intricate financial matter with the creation of shell companies. And a judge, for example, albeit he's a very specialist judge, he understands the law, he may need the assistance of these specialists to guide him in understanding of that assessment of evidence. So, Mr. President, again, time is always my enemy in this most respectful place. I thank you most sincerely for the opportunity to make a contribution in this debate.
Senator Mark.